This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
This is my lord. Kollol Go Thakurta and another versus Biman Basu, Chairman, Left Front, West Bengal. At the top, your lordships will find reversed in Biman Basu versus Kollol Go Thakurta. Why I am citing, my lord, I will show how this court has proceeded in a suo motu contempt application. That is the reason. And with great respect to your lordships, my lord, that kindly do not. I'm just saying that your lordship is also following that procedure. Kindly come to paragraph 11. The contempt petition has two petitioners, one Sri Kollol Go Thakurta, and advocate of this court, and Sri Horace Bollab, a citizen. In the said petition, the allegations against Sri Basu are that in respect of the said order, an appeal has been filed before this court and the said appeal was pending. Despite the fact that the appeal is pending, Mr. Basu held an emergent meeting on 4th October 2023, along with other left front partners, are decided on a strategy to violate the said order, along with other left front partners, and decided on a strategy to violate the said order, and told the press that on 8th October, which is weekday, a mass convention will be held at Mahajati Sadan to protest against the said order. It was also stated that Sri Basu declared before the press and the electronic media that he will flout the restriction imposed by the said order, and also asked all the important organizations which are showing allegiance to the left front for holding procession and demonstrations and defy the said order of this court. This statement of Sri Basu was reported in almost all the leading newspapers of the city on so and also on subsequent date. It was also stated that Sri Basu declared that he would organize procession from the College Street to Rani Raspberry Avenue on weekdays in violation of the said order. And Sri Basu commented that the learned judge who passed this said order did not understand the spirit of Calcutta and such people should quiet the city. Sri Basu is stated to have drawn a parallel between the agitation over the Rowlatt Act during the independence struggles and the agitation over the said order, and also say a go back slogan can be raised against the said learned judge. It is also alleged when Sri Basu so and similar. Then Miller, kindly come to paragraph 33. Not 33 is required, Miller, 43 kindly come. In a three judges bench of the Supreme Court, in three judges bench of the Supreme Court in the case of Sukhdev Singh versus Honorable Chief Justice Teja Singh, Year 54 Supreme Court, this was recognized by the Apex Court by holding that power of High Court to initiate proceeding for contempt and punish whenever necessary is special jurisdiction, which is inherent to all courts of record. Dealing with the question in paragraph 34 of the report, the learned judge held that the High Court could deal with the contempt allegation content summarily and adopt its own procedure. All that is necessary is that procedure should be fair and the contemptor is made aware of the charge made against him and given a reasonable opportunity to defend himself. This principle has been repeated by the Honorable Supreme Court subsequently also in so and so. Paragraph 11, and at page 162 of the report, it has been reiterated that the High Court's power for punishment of contempt has been preserved by Constitution, thereby are also inherent in a court of records. The learned has that only carved on such power is proceeding. Let kindly leave then kindly come to paragraph 50. In SK Sarkar 50, in SK Sarkar, the Supreme Court clarified that the object of prescribing procedural modes of taking cognizance under Section 15 of the said Act is to safeguard the valuable time of the High Court and Supreme Court for being wasted by the filing of frivolous contempt petition. The learned judge also made it clear that if the High Court is prima facie satisfied that the information received by it, even on the basis of a petition about the commission of contempt, is not a frivolous one, and the contempt alleged is not merely technical or trivial, it may in its discretion act suo motu and commence action against the contemptors. It has, however, been made clear that such mode of taking cognizance suo motu is to be resorted sparingly, and frequent use of this may render the safeguard obvious. But it cannot be said that the High Court cannot take suo motu cognizance of criminal contempt just because a petition has been filed without the written consent of the Advocate General, even if the petition discloses prima facie materials for taking cognizance. Then, my lord, kindly come to paragraph 63.
Sorry, Mr. Bandyopadhyay, which paragraph?
Paragraph 63, my lord. I am showing this all. Comments which are outspoken, frank, and candid may be fair, but good faith must be writ large all over them. The reason behind such comments should show whether they are in good faith. But when good faith and reason disappear, and any person or of ordinary prudence reading the comments discussed in them as attempt to defy the denigrate the judicial process in a matter which is sub judice, as in this case, the comments cease to be fair. This court, however, does not say that fair criticism of a judgment is not permissible. This can always to be done, as justice is not a cloistered virtue, and it's because of such fair criticism that justice delivery system will also improve. A person may not like an order of the court, so and so may not leave this. Then kindly come to paragraph 68. Understandably, the definition of criminal contempt under section 2C has been worded in generic terms and very broadly with expression like tends to scandalize, tends to interfere in clause 1, 2, and 3 of section 2C of clauses, concludes with the expression in any other manner. Expression of every wide import have thus been deliberately used to define what is criminal contempt, as it may take various forms. Supreme Court also accepted the same, so where it was laid down that the definition of criminal contempt is wide enough to include any act by any person which would tend to interfere with the administration of justice or would lower the authority of the court, so and so. Then kindly come to Miller, paragraph 78. In this country, everyone has to live and function under certain constitutional imperatives, and one of such imperatives is to accept and submit to the authorities of court. Under a constitutional government, such authority has to rest in some institution which are manned by judges. In the absence of such constitutional dispensation, where there will be chaos, therefore the verdict of the court is to be respected and accepted, as has been said, not necessarily by the authority of its reason, but always by reason of its authority. Then, my lord, this judgment has been reversed. I will show that. 2010 8 SSA, page 673. Thank you. Kindly come to Miller.
Just an academic question. What is the maximum amount of fine that can be imposed under the contempt? 2,000 still?
2000?
Or has it been increased?
I am checking it.
6 months there.
কত আছে এটা? Fine. দেখেন, just I am checking it.
Yes, yes.
In the meantime, let me kindly come to paragraph 6. The respondent in this appeal moved a কত? 2000. Or with both. The respondents in this appeal moved a contempt petition in the High Court on 30th October 2003 with a prayer to initiate appropriate contempt proceeding against the appellant for making deliberate and willful derogatory, defamatory, and filthy statements against Justice Amitabh Lala, which are widely published in the newspaper and electronics media. In this petition, the respondents pleaded that the derogatory, defamatory, and contumated statement and remarks to answer for the purpose that filed a petition. Here, affidavit, nothing. Distinction, nomenclature is not the substantive things. Now, 7. A division bench of the Calcutta High Court, vide its order dated 17th October 2003, passed the following order. Heard After hearing Mr. Ali Learned Counsel moving this petition and perusing the issue, Bortoman dated, we are of the view that a rule be issued. Rule is made returnable on 7th November 2003. This court, however, makes it clear the records of this case may be placed before the Honorable the Chief Justice for assignment of this rule. For hearing before any bench of this Honorable the Chief Justice may think fit. Therefore, my lord, paragraph 7, after hearing Learned moving this petition, what important factor is moving. Here, affidavits were moved, mentioned. I will read later to order. And the issue, Bortoman so we are the view. Then, my lord, paragraph 8. This order was followed by a rule requiring the appellant herein to show cause why he should not be committed to prison or otherwise penalized or dealt with making deliberate and willful derogatory, defamatory and filthy statements against the sitting judge of this court, Honorable Justice Lala, as well as making such derogatory, defamatory, filthy language remarks and statements in front of transfer of the press, electronic media and open meeting regarding the order dated 29th September to the passed by the Justice Lala. The appellant was required to be personally present on 7th November before the court. The appellant was accordingly served to answer. Paragraph 8. Then, my lord, kindly come to paragraph 15. In the present case, we are concerned with the criminal contempt. Criminal contempt is defined in section 2C. The Contempt of Courts Act is the criminal contempt means the publication. And a definition has been given. 16. In case of criminal contempt, when other than a content referred to in section 14, the manner of taking cognizance has been provided for in section 15 of the Act. This section interior provides that the action for contempt may be taken by the Supreme Court or the High Court on its own motion or a motion made by the Advocate General or any other person with the consent in writing of the Advocate General. Then, my lord, kindly come to paragraph 16 to 23. Yeah, yes. 70. The question that arises in the present case is whether the High Court can entertain a contempt petition filed by a private person without the consent in writing of the Advocate General. For determination of this issue, it will be relevant to note that the observation of the Channel Committee, whose recommendations were taken into consideration for enacting the Act, the committee observed. In the case of a criminal contempt not being contempt committed in the face of the court, we are of the opinion that it would lighten the burden of the court without in any way interfering with the sanity of the administration of justice. If action is taken on a motion by some other agency, such a question officer would give considerable assurance to the individual charged and the public at large. Indeed, some high courts have already made rules for the association of the Advocate General in some category or cases at this. The Advocate General may also move the court not only on his own motion but also at the instance of the court. In SK Sarkar vs. Binay Mishra, this court approvingly referred to the recommendation of the committee and observed if the High Court's acts on information derived from its own sources, such as formal perusal of the records of a subordinate court or on a reading of a newspaper, or hearing public speech without there being reference from the subordinate court or the Advocate General, it can be said to have taken cognizance on its own motion. But if the High Court is directly moved by a petition by a private person feeling aggrieved not being the Advocate General, can the High Court refuse to entertain the same on the ground that it has been made without the consent in writing of the Advocate General? It appears to us that the High Court has in such a situation a discretion to refuse to entertain the petition or to take cognizance on its own motion on the basis of the information supplied to it in that petition. If the petitioner is a responsible member of a legal profession, it may act suo motu more so if the petitioner advocate has in his case that should act suo motu. The whole object of prescribing these procedural modes of taking cognizance in section 15 is to safeguard the valuable time of the High Court of the Supreme Court for being wasted by frivolous complaints of contempt of court. If the High Court is prima facie satisfied that the information received by it regarding the commission of contempt of subordinate court is not frivolous and the contempt alleged is not merely technical or trivial, it may in its discretion act suo motu and commence and proceeding against the contemners. However, this mode of taking suo motu cognizance of contempt of subordinate court should be resorted to sparingly where the contempt concern is of a grave and serious nature. Frequent use of the suo motu power on the information furnished by an incompetent petition may render this procedural safeguard provision subsequent to the OTS. In such cases, the High Court may be well advised to avail of the advice and assistance of the Advocate General before initiating proceedings. In State of Kerala versus MS Mani, this court said the requirement of consent of the Advocate General, Attorney General, Solicitor, where any person other than the state law officer makes motion in the case of a criminal contempt in a High Court or Supreme Court, as the case may be, is not a mere formality. It has a salutary purpose. The state law officers, being the highest law officers at the level of the state and center, as also the officers of the court, are vitally interested in the purity of the administration of justice and preserving the dignity of the court. They are expected to examine whether the amendments in the proposed motion of a criminal contempt are made vindicating public interest or personal vendetta, and accord to decline consent postulated in the said provision. Further cases found to be vexatious, malicious, or motivated by personal vendetta and not in public interest will get filtered at that level. If a motion of criminal contempt in the High Court or Supreme Court is not accompanied by the written consent of the aforementioned law officer, the very purpose of the requirement of prior consent will be frustrated. For a valid motion, compliance with the requirement of Section 15 of the Act is mandatory. A motion under Section 15 is not conformity with the provision of Section 15 is not maintainable. In MS Mani, the consent of the learned Attorney General was obtained after filing of the contempt petition. This court held that motion to take action against this respondent therein was not made with the consent of the learned Attorney General or Solicitor General, therefore is incompetent. This court observed subsequent obtaining of the consent, in our view, does not cure the initial defect so as to convert the incompetent motion into a maintainable petition. In PN Duda, etc., Millard, this is all have said up to Millard, paragraph 23. Bal Thakare's case also, Millard, is considered. Paragraph 24. The High Court in the present case, rested in its conclusion relying on averments made in the petition stating that even a suo motu contempt proceeding may be initiated at the instance of the petition on going through the newspaper. But it noted that there is no prayer in the contempt petition filed by the respondent to initiate suo motu proceeding. We are unable to sustain the finding of the High Court in this regard, for the same is not supported by any material available on record. The order 37 and the rule issued in clear and categorical terms reflects that the law was set in motion exclusively based on the averments made in the petition and the affidavit of the verification filed in support of the petition and the arguments of the counsel. There is nothing on record suggesting that the contents of the petition were treated as information placed before the court for initiating the contempt proceedings suo motu by the court. The contents of the petition of the respondents, their affidavit of verification dated 13th October, the exhibit annexed to the said petition, and the arguments of the counsel alone constituted the foundation based on which the law was set in motion. And before the Lordship's court, Millard, if I have seen the video that the several senior counsels have argued, and on the very first day they insisted for issuance of a rule. Then your Lordship said, no, we will ask for the affidavit. Vigorously the learned senior counsels have argued. Your Lordships can remember. Therefore, it is a case of, well, I wanted to make it, not by the High Court. I am reading. The order there is nothing on record suggests that the contents of the petition were treated as information placed before the court for initiating the contents suo motu by the court. The contents of the petition of the response, their affidavit of verification of the response, the exhibit and the arguments of the counsel constitute the foundation based on which the law was set on motion. The petition itself is not styled as any piece of information that was placed before the court for its consideration. It is not a case where the High Court refused to entertain the petition and took cognizance on its own motion on the basis of the information supplied to it in the petition. The record does not bear any such proceedings of the court. Had it been so, the respondent would have been nowhere in the picture. Here the respondents are all in the picture. Petitioners are on the picture. All are fighting. Last day also said, that's the reason I said, kindly pass an order, then I will give it. Give the affidavits. It is true that any person may move the High Court for initiating proceeding for criminal contempt by placing the facts constituting the commission of criminal contempt to the notice of the court. But once those facts are placed before the court, it becomes a matter between the court and the contemptor. But such person filing an application of petition does not become a complaint or petitioner in the proceeding. His duty ends with the facts being placed before the court. The court may, in appropriate case, in its discretion, require the private party or litigant moving the court to render assistance during the course for the proceeding. It has not been done. Your lordships have not invited them to render assistance. On their own, they are arguing the matter, trying to establish the contempt. Your lordships have never, from any order, I have seen that your lordships have sought for assistance. Then, a contempt is a matter between the court and the alleged contemptor. Any person who moves the machinery of the court for contempt only brings to the notice of the court certain facts constituting contempt of court. After furnishing such information, he may still assist the court, but it must always be borne in mind that in a contempt there are only two parties, namely the court and the contemptor. Thus, the person bringing the facts constituting contempt to the notice of the court can never be a party to the lease, nor can join the proceeding as a petitioner. Similarly, is the view taken by this court. Your lordship's order will show that they are the petitioner. Your lordship's order will show that they are the petitioner. That's all right. Order will judge the charge. On the very first day, your lordships are treating them as a petitioner. Next. Then come paragraph 28. In the case in hand, it is evident from the record that the respondents were continued to be shown as the petitioners in the contempt case before the High Court and participated throughout as if they were prosecuting the appellant. There is no order reflecting that the court, having taken note on the information made before it initiated suo motu proceeding on the basis of such information, furnished and required the respondents only to assist the court till the disposal of the matter. On the contrary, the respondents are shown in the petitioners in the contempt case before the High Court. It is thus clear it is the respondents who initiated the proceeding and constituted the same, but without the written consent of the Advocate General, as is required in law. The proceeding therefore were clearly not maintainable. 29. In what manner the suo motu power may be exercised in appropriate cases dealt with by this court in J.R. Parasar versus Prashant Bhushan, in which it is observed, in any event, the power to act suo motu in matters which otherwise require the Attorney General to initiate proceeding or at least give the consent must be exercised rarely. Courts normally reserve this exercise to cases where it is either derives information from its own sources, such as from a perusal of the records or on a reading of a report or in a newspaper or hearing the public speech or documents to speak for itself. Otherwise, subsection 1 of section 15 might be rendered odious. Then 30, while dealing with the importance of the procedure for taking cognizance of criminal contempt, other than a contempt referred to in section 14 of the court in Baltakare, observe the decision in Duda's case was seen and appreciated in the light of what we have noticed here in respect of contempt petition and the powers of the Chief Justice. It would be clear that the same prescribe the procedure to be followed by High Court to ensure smooth working and streamlining of such contempt action, which are intended to be taken up by the court suo motu on its own motion. These directions have no effect of curtailing or denuding the power of the High Court. It is also to be borne in mind that the frequent use of suo motu power on the basis of information furnished in a contempt petition otherwise incompetent under section 15 of the Act may render the procedural safeguards of the Advocate General concerned nugatory. We are of the view that the directions given are legal and valid. Paragraph 31. In exercise of the conferred by section 23 of the Contempt of the Constitution of India and other enabling powers in that behalf, the High Court of Calcutta made the rules to regulate the proceedings for contempt of itself or of a court subordinate to it under this Act. The rules are known as the Calcutta High Court Contempt of Court Rule 9. These rules inter alia provide that proceeding in a criminal contempt may be initiated A, on its own motion by the High Court under section 15 or on its motion founded on a petition so and so, or C, on a motion founded so and so, so and so. Consent of a writing of the Advocate General under section 15 or this is there. Now, but point which I have argued that the Chief Justice, that contempt, suo motu contempt has to be initiated by judicial order, not by an administrative order. And the rule can be issued by the bench which is having the determination, and only rule can be assigned. These are not argued and decided. Rather, if I have checked up the judgments, first time it is being argued. Initially, which I argued. That is the first point. Now, paragraph. Now, paragraph 34. In the present case, petitioner won before the High Court is a practicing advocate and argued the case in person. Here is that even the senior lawyers are arguing. Bar library has come. All lawyers are coming, arguing. So far as petitioner number 2 is concerned, he was represented by more than one lawyer. We have meticulously examined the contempt petition in which there was no prayer for taking into suo motu action. The proceeding before the High Court was initiated by the respondent by filing contempt petition under Section 50. This petition was vigorously pursued and argued as a private petition. From the material available, this is the important point. Whether it is a private or not, like a private petition.
Mr. Bandyopadhyay, can we ask a question to you?
Yes, my lord.
I mean, without going into the merits of the allegations, definitely you have your point on that. Now, suppose in a case where there is an allegation against, in your case, against an admitted person who is the spokesperson of the ruling party. Now, there, the Advocate General, consent of the Advocate General, undoubtedly, Advocate General is supposed to be an independent functionary, constitutional functionary. But at the end of the day, Mr. Bandyopadhyay, the Advocate General is the representative of the state, which is governed by a ruling party in the parliamentary system. Now, whether if one of the alleged contemners is the admitted spokesperson of a ruling party, whether the consent of the Advocate General, the prerequisite of that is diluted somewhat.
But would your lordship in that case undermine the office of the Advocate General? There are judges who are in the political parties.
Judges don't represent the political party.
The judges,
Advocate General is representative of the state.
excuse me,
Yes.
mindset. There are judges, before being elevated, they were in the political parties. Supporters of the political parties.
Maybe.
Then in that case, when he becomes judge, do I expect that the judge will, shall I take it, the judge will decide the matter on a political ground?
No, Mr. Bandyopadhyay, there is a difference here.
But-
Advocate General is supposed to represent the state.
Represent the state, how can, my lord, how can your lordships can come to this conclusion that Advocate General will act in terms of the ruling party? This is an aspersion. Sorry, my lord. The high status constitutional post. If your lordships think no, Advocate General will not give permission because the Advocate General is appointed by the state and state is ruling party.
Mr. Bandyopadhyay, my brother did not mean in this case. It's a general academic question that. Yes.
Forget about this.
Yeah,
No,
yeah.
he said
This proposition.
Trinamool Congress support spokesperson said that. That's the reason I'm saying.
Yes.
Manoj, the moment, let me take it, winner. Chief Election Commissioner was the Secretary of the Cooperative Department. 1 month, 1 year before he appeared before us in standing committee. Whatever the Home Minister is saying, he is doing that. When he has Chief Election Commissioner, then they will act on the in terms of the government.
No, there's a difference between what was and is, Mr. Bandyopadhyay. Advocate General is the representative of the state in the court. That remains.
Do your lordships have come to anywhere, any findings, any materials that the Advocate General is acting in violation of law? Mullah, that would be too wide to, Mullah, that in that case, with great respect, we will undermine the Advocate General. That is not expected.
Which is a valid answer, Mr. Bandyopadhyay, to our question.
We cannot undermine.
Yes.
And Duda's case, it has been held. If the Advocate General, Attorney General doesn't give the permission, judicial review is there, amenable. Even it is rejected, judicial review is amenable. P.N. Duda's case. My lord, Advocate General action is also under judicial review in any in such an administrative case?
All right.
When there is a safeguard, judicial review is there. Why not? You will not go to the Advocate General. If the Advocate General pass order on merits, that's a subject to judicial review.
That's a sufficient answer, sir. You can proceed.
জানি আমি ভাই 1988 এর জাজমেন্ট আমার প্রথম কন্টেম্পটের জাজমেন্ট পড়া ফার্স্ট জাজমেন্ট আই রেড that Juda, he was a law minister, read this criminal contempt first in 1988. Ever I know that, and that time he used to read every line. Beautiful days of life. With this capital we are continuing now. Nonetheless, in the present case, petition number 1 before the High Court is a practicing advocate and argued with this person. So as petition number 2, he was represented by more than one lawyer. We have meticulously examined the contempt petition in which there was no prayer for taking suo motu action against the appellant. The proceeding before the High Courts were initiated by the respondent by filing contempt under Section 15. The petition was legally produced and argued a private petition from so and so. Therefore, my submission is there. Leave aside Advocate General consent. This is not a valid contempt. This is a private motion approved by the Honorable Chief Justice in his administrative capacity.
Very short point, what you are saying then, this is not a suo motu contempt proceeding. It is at the instance of private parties that would not be maintainable without the prior consent of the Advocate General.
Now, therefore, point is there, my lord. If the Chief Justice would have taken cognizance on the basis of any information, news or video, then I would not have argued these points. And that too in the judicial side, not in administrative side. Let's I read it, my lord. The relates to CLP so and so filed with the leave of this Honorable Court, the Chief Justice, Honorable Justice Soitali Chatterjee, thus on 28th April to the. Therefore, High Court, Chief Justice Court granted leave to file the affidavits. Therefore, it is not an information to the Chief Justice. Both the affidavits are related to the acts of obstruction of justice, intimation, advocacy, scandalization of the court, and interference to and so, and hence praying for taking up the matters as suo motu proceeding for criminal contempt. Who is under the both the affidavits are filed in Rajasthan, the matters are mostly humbly placed before Lordship for appropriate order. This is the Samrat Gupta officer on special duty of this honorable. Then the matter was mentioned before the courtroom number 1. Today, by several learned who are informed in their submission that the incidents which occurred on Swansea is a clear interference to the administrative justice and a threat meted out to the judiciary, and the learned members of the bar, video clipping was shown to us in which it was seen that one person was stamping the photograph of the Honorable Judge with his feet. The interview given to the concerned YouTube channel was translated and explained to the undersigned in English, from which it appeared that prima facie clear that the person was mentioning about the names of the Honorable Judges present and past. There were also a mention about order passed by the Honorable so-and-so. The matter was mentioned. Why the Chief Justice did not pass any order in court? I would not have argued this much. I do not understand. If a matter is mentioned for bench having a determination, why that bench would not take the cognizance of the matter? And thereafter it was taken in the administrative side. This is not known procedure of law. Court, my lord, in your lordship judicial capacity is granting leave. Matter is being mentioned, take up the matter in the list. And discretion is there that when the matter will be taken up, not taken up. I am not on that. Then why in an administrative side? This is unknown procedure, my lord. Then on that day, if the rule was issued and thereafter it was assigned to your lordships, then I would not have argued all these points. I have placed. Now, my lord, from the affidavit I have shown to your lordship that I am not connected with this matter. My lord, I have some difficulties. This 4:18, I have to rush. I have
Rush.
another 45 minutes.
Yes,
I have promised. I have missed one matter in 12:30. It's a very
Monday same time.
kindly just
Next Monday same time.
yes. If I cannot come, my lord, I will do it virtually. That will Lord kindly permit me. If I cannot come, I
No,
will
no. Tell us when will you be here? We'll give you that day.
Lord, that will be- Huh? Thursday to already the time here.
21st July.
So-
Very much.
And yesterday that 2 o'clock happened now. Then the all places is today. Last Friday. This is whole. Once it.
17 তারিখ আনতে দাদা
17 তারিখ তুই রাজি আছিস?
17 তারিখ আমার কোনো অসুবিধা নেই।
17, my lord, kindly.
আমার
Another half an hour, so I will finish it. I'll finish it.
ওই সেম আগের অর্ডারটা দেখে নিও মিস্টার কল্যাণ বন্দ্যোপাধ্যায় লার্নেড
17 tak best.
senior advocate representing
I will take another 20
the
minutes.
respondent number 8 in CRLCP 7 of 2025 resumes his argument but does not conclude. বুঝেছো একই order. Next, list the matter once again on July 17, 2025, marked 3:30 p.m.
grateful, my lord. Only one indulgence may I seek, my lord. Mr. Bandyopadhyay has relied upon certain writ petitions in his affidavit, my lord. Certain writ petition numbers have been relied upon. Yes, Mr. In the affidavit filed by the alleged contender number 8, my lord, I have requested my advocate on record, my lord, to, my lord, disclose the prayer portions as well as, my lord,
I don't
the
have. I don't have.
I have them, my lord. If I can file them, if the court gives us leave, my lord, we can make a compilation, file it for the convenience of the court, and I will
prefer to
have-
file.
You fully
I will. We will.
matter. I don't have any objection.
Give advocate and
Yes, certainly.
You fully contest the matter. I have no objection. I want that you fully contest.
your plane will leave. Go.
No, not bail. I want bail matter. I have to
Bail,
argue.
bail.
Then thereafter bail.
Very well. Thank you.
Sorry, my lord. Kindly excuse me.
No, sure.